All right, so this is just We the People News, people. All right. I'm not an attorney, so I'm not going to give legal advice. It's just my opinions at times, but that's all it is. Just opinions. All right, this is going to be a learning video, okay? And take it as you wish, okay? I'm not going to be giving you any type of legal advice, so I just happen to think outside the box, right? I never look straight forward. I always look around me, be able to protect myself by any means necessary. And that's what all of us should do, right? Because everything we're going by is mostly hearsay. You call an attorney and ask for advice, well, it's hearsay. You didn't look it up for yourself, did you? All right, what do you guys think? Should we proceed forward? Let's go.
Absolute qualified immunity. Remember we spoke about those child support agencies, those child welfare agency employees coming about, acting as the one with the information when they create a cloud of legality within the family courts or the county courts or state courts or the agencies. This is the reason why they can come in front of your door confidently, talk a bunch of trash, and do things arbitrarily. They don't know the details, but someone within the hierarchy of their corporation have conditioned them to be comfortable because they know this exists. You must be aware of it also. You must not be blind to these things. There is so much that's going on that people are not aware of. Plaintiffs have stated claims that defendant violated their procedural due. Look at that. Plaintiffs have stated claims that defendant violated their procedural due process rights. On count 3, substantive due process right. Count 2. Again, on Patreon, we go over clearly the difference between these two. In this video, we've given summarized examples here and there. And their first...
Definitely look up them two and see what the difference is. We all just keep going by due process, due process, due process. But which one we keep saying due process? Which one of these?
Amendment rights to intimate association, count 1, 2, 5. Plaintiffs have also stated claims that defendant Mericold and Caprio have supervisory liability under Section 1983, count 4. Defendants argue that they have absolute and qualified immunity from plaintiff's claim. Interesting. They go on to say that the Third Circuit has held that child case workers, listen to this, child case workers are entitled, quote, are entitled to absolute immunity for their actions in petitioning and in formulating and making recommendations. So one of the ways you can bring criminal charges, because they do criminally charge parents for suppositions of child-related matters. One of the ways you can do that, as we go over in Patreon, is you can... Beautiful people, welcome back. Let's speak of parents and their children when it comes to circumstances that children are taken away from their parents. There are a plethora of reasons where...
So if you want, you could pause this for Texas, okay? You may use this into your other states, but you're going to have to find out where it's at in your states. But this is kind of Texas, so kind of read through this. All right.
Representatives of some entity will have as to why they say they are taking those young ones away from the parents. We're not looking at that plethora of reasons. We're looking at two very simple things: the substantive due process and the procedural due process involved. There are two types of due process, and those are the two types that we just mentioned. A whole separate video on that is already done on Patreon, but on YouTube, we're going to go over other examples relating to it. But know that you need a foreknowledge of the different types of due process. for most of this to make sense. Because what we're going to entertain here is we're going to show you the importance of what's constitutional and the fact that this important constitutional provision is not being followed when children are taken away from parents. And then we're going to show the intricacies when it comes to the procedural aspect of it, which is a form of due process, whereby those taking those children are actually afforded immunity. A lot of people know about qualified immunity, which is applicable to acting judges, applicable to municipal employees who are armed. And qualified immunity has its origin in the 11th Amendment, which we've already created 2 separate videos here on YouTube dedicated to that. So I implore you to watch that for you to get the foundational knowledge on the origin of sovereign immunity as it refers to the Constitution, albeit anything after the 10th Amendment is not Bill of Rights, but is in fact specific to the representatives and the enclaves of the United States. But then that's just qualified immunity. You also know that other types of immunities branch out of qualified immunities, like prosecutorial immunity. And then other representatives of municipalities and its agencies can sharecrop prosecutorial immunities if they're. Now, these founding documents called constitutions exist also on a state level in each state.
Now, this is a blanking in and out. He's giving you little gold pieces, okay? Now, pause the videos, kind of reroute yourself, and kind of listen to what he says, right? Immunities from this, this, and this, and this. Corporations giving themselves a lot of umbrellas, okay? That really constitutionally they don't have. Just saying.
Have their own respective constitution. So whatever it is we're mentioning here on the United States level, know that the same principle, and in many cases the exact verbiage, word for word, clause for clause, exists on a state level. When it comes to parents and children, specifically the children being taken away physically from the parent, there's this thing called the First Amendment. Usually within these...
Now listen to that word. How are they taking your children away? From one of the parents or both? Alright, CPS does the exact same thing, by the way, y'all. This may be child custody thing, but it's also CPS doing the exact same shit. Alright? They're using the First Amendment to take these kids away because they're a corporation.
Things called the Bill of Rights, First 10 Amendment on the United States level. One article or one specific bill can have about 6 or 7 clauses, or 3 or 4 clauses, and each of those clauses will represent specific rights. Most people usually combine 2 specific clauses that have about 3 different rights or 2 different rights and categorize it as one. That is another little subtle intricacies. This thing called the First Amendment speaks about several things. One of those things it speaks of is right of association. The right of association can be used in court cases where attorneys are being compelled upon you. That is, if you don't know how to refuse an acting judge, either by right or by showing cause. That is, if you don't know how to put, if it's a civil case, of preponderance, if it's a criminal evidence beyond reasonable doubt. Or you can use the lower standards like probable cause, which is a standard or a weight of evidence. There's probable cause, clear and convincing, preponderance of evidence, etc., etc. The right of association can be used for court-related matters if you can show through preponderance of evidence or evidence beyond reasonable doubt that there's conflict of interest if that attorney was put upon you. The right of association can be invoked when it comes to your properties, tangible or intangible. In this specific instance of a child and a parent, the right of association can be invoked. Freedom of religion, speech, and press, right of petition. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievance. So
Now we're going to stop right there. So get your little books out, right? Write these things down separate. Separate, 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 separate. 1, 2, 3, 4, 5. We always keep on saying there's 5 things, right? But when you separate them all in a list, you'll find out there's a little bit more than that.
where in this exact portion that we just read, where does it ever mention anything about right of association? Believe it or not, we just did. Many people who speak about having right speak of it from a prima facie aspect. Meaning, look, it's right there on a pen and paper. They don't see beyond what that word substantive truly means. This is where you need to see the subtleties for you to know where your rights are. Let's read it again. Congress shall make no law respecting the establishment of religion.
Quick deal on that. When you guys actually go into court, right? I write to, let's just say you and your wife. This is the reason why it has to be 50-50%, right? You're Catholic and the woman's Baptist, vice versa, right? Well, that offspring has a right to know both sides, 50-50. If it does not get 50-50, not only that they're violating your rights, violating the offspring's rights, and the mother or father who actually has more majority of time is gaining more than everybody else, right? So let's just say average mom has Tim 90% of the time, right? Well, the father's rights of religion is only 10%. Well, no courts can actually tell you that you have to waive your religious rights. Just something to think about, right? It must be 50-50 to your offspring. Okay? Just saying. That is one, and all of them. Separate it out. Figure out which one of these are actually violating your rights. And they're saying you don't have constitutional rights. Objection, Your Honor. Does CPS or the sinner using the right to grievance, permission to grievance against I? Well, yes, they are. Well, that's the First Amendment. So, are you saying they have rights to the First Amendment and I do not? Is that what you're saying, Your Honor? Just saying. Paper or on stand. Okay?
That is one substantive right. That is one substantive due process mentioned. But listen to this closely. Or prohibiting the free exercise thereof. This second clause, where it says Congress shall not make any law prohibiting the free exercise thereof.
Mm-hmm.
The inability of the Congress to make a law to stop you from respecting a religion has its root in your ability to associate with others. If you notice very carefully, the second clause is not...
We're going to stop there, right? The clause. Freedom of speech. So is these courts actually saying you have zero rights of free speech to your own offsprings? So think about it. Violation of the First Amendment. Free speech to your offsprings. Why does that offspring get to hear what the mom or dad has to say more than the other?
Or specific to just religion. It makes reference to the first clause, and so long as it's the benefit of the public. Do you not know that these caseworkers that work for these private corporations, like we've shown on Patreon, do you not know that they are using the right to petition right here? Congress shall make no law prohibiting the right of the people peaceably to assemble and to petition the government for redress of grievance. This last
Boom, right there. This child support agencies, CPS agencies, all gathered around to protest their grievance against the government against you. All right? They're using the First Amendment that they're telling you you don't have. Conflict of interest right there, y'all. The courts are letting them do it with the First Amendment, but saying you don't have a First Amendment. That is conflict of interest. Again, I'm not an attorney. I'm not giving legal advice, okay? It's just my opinion. It's just that little simple thing right there.
clause of the right to redress a grievance and petition, right of petition, is exactly what they're using against you and your children. They are flipping the table so quick. Complete 56-minute video on the Patreon page. Take care, Vessel.
All right. So I don't know too much about his Patreon. Jeez, I think this thing got stuck. There we go. Sorry about that. Jiggle, jiggle, jiggle. Again, I don't have fancy equipment. I'm just doing with what I got.
If you notice very carefully, the second clause is not limited or specific to just religion. It makes reference to the first clause, and so long as it's the benefit of the public.
All right.
Do you not know that these caseworkers that work for these private corporations?
So, to go to them and track them down, which again, I'm telling you, I don't know how to do that yet on the description. SUBTLE. Other word, SUBSTANCE, just in case you can't read it. All right. So, don't be squared. Meet me there. Diesel We the People News. Till next time, y'all. Bye.